251 is now in session.
Please be seated. We're here for oral argument in case number 1CA-CV 160496, Fish versus Lifetime Fitness. I'd alert counsel that these proceedings are being audio and video recorded, so we would ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. If you, appellant's counsel, you're responsible for watching the clock to reserve a portion of that time for rebuttal if you so desire. We've read the briefs and have discussed this case in conference. Counsel, you may proceed.
Good afternoon. I'm Richard Langerman here on behalf of appellants June Fish and Mitchell Fish. I'd like to reserve 5 minutes of my time for rebuttal. The issue presented today is quite simple. It deals with the sufficiency of the evidence. In the trial court, the defendant moved for summary judgment and argued that there was no evidence to establish causation on either whether the plaintiff was injured and whether her neurostimulator was damaged. The basis of the motion had to do with the lack of expert testimony. There were two factual issues on which the defendant argued that expert testimony was required. Whether the treadmill, which is central to the incident, had the capacity to deliver the electric shock that the plaintiff alleged she suffered, and whether the neurostimulator was the type of thing that could be damaged by such an electric shock.
What type of shock did the evidence show she received?
The plaintiff testified that she described it as a jolt, a shock of electricity that originated from her right foot and traveled through her body to her left hand.
And I understand that a layperson knows what a jolt feels like, but was there any evidence as to whether this was static discharge, whether it was line current? What type of defect in the treadmill would have given rise to what type of shock? Was there any evidence on that?
Yes, Your Honor. The electrical engineer witness, Scott Baer, that we presented an affidavit testimony from, testified that by design a mechanical treadmill, one in which a rubberized belt is used,
so we're talking about
electrostatic
discharge then,
creates an electrostatic buildup,
right? And
manufacturers of those types of devices are aware of that. It's a well-known phenomenon, and they design a anti-static line to discharge that away from the user. This particular item, this particular treadmill, was missing a functioning static line. So the evidence was this: the piece of equipment has the capacity to discharge if not accompanied by or designed with a functioning anti-static line. The maintenance personnel from the gym testified that the line on this particular piece of equipment was missing at the time.
Okay.
So from those two pieces of evidence, a jury could conclude that in the absence of that line, electricity could be discharged to the user. Mrs. Fish testified that she, in fact, suffered from an electrical discharge.
Okay, and so if we assume for sake of this argument that there's enough evidence to establish those facts, the heart of this claim is that the electrostatic discharge then proceeded to damage a separate piece of electronic equipment, right?
It would technically be electronic, but yes.
That's what I thought I said. So you have an electrostatic discharge that then travels through the plaintiff's body. And the claim is that that damages a second piece of electronic equipment.
There's two claims, two damages claims. One is she suffered an injury. So there are 3 medical records that indicate she suffered an injury. That's one thing.
But the injury was not from the electrostatic discharge itself, but rather the effect it had on the electrostimulator.
No, Your Honor, that is not what the claim is. So when she was first shocked, she did something like that, and the movement in her neck caused an injury to her, or an exacerbation of her pre-existing neck injury. The primary care physician noted a neurologic consequence, a mental fogginess, presumably from the shock. He referred to it as a altered mental status as a result of shock. She then went to the emergency room upon his recommendation, and their diagnosis was paresthesia, numbness, and, quote, electrical injury. And then they recommended that she go be evaluated by the implanting physician, who was in California, and he documented.
Let's stop there, because now we're bleeding over into a separate type of claim, and I thought you were defining 2 claims, which would have been a new perspective for me. One, the injury from the physical reaction to a shock, and then a second injury from some harm to the electrostimulator. Are those 2 separate claims or not?
Physical injury is one type of damage. Damage to your piece of equipment.
That's not my question. My question is, would the physical injury, have you advanced a claim that there would have been physical injury that could have happened had the TENS unit not been anywhere in her body?
Yes.
Okay. So that's claim 1. Is there's an injury flowing simply from the reflex reaction to an electric shock?
It's more than the reflex. The numbness in her face and arm was not from her head whipping about. It was from being shocked.
Okay. And you don't think you need expert testimony to demonstrate that that's possible?
We have 3 experts, 3 treating physicians who have said in their records, Dr. Woodbeck, the PCP, said altered mental status as a result of shock. The emergency room said paresthesia and electrical injury, and the anesthesiologist.
I understand that, but what's not clear to me, since we have 2 electric actors in this case, is whether those reports say that the injury was due to the initial shock and the reaction to it, or the initial shock and its effect on a device whose stated purpose is to deliver shocks.
The purpose of the device, it's not a TENS unit. It is similar in the sense that it delivers an electric pulse. It's not a shock. That might be a lay term that someone like me or you or Mrs. Fish might use.
I've been trying to use shock to make the conversation flow, but I think you're right that there is no such thing as a shock in the expert world.
If you look at Dr. Joel's October 5th, 2012 note, what he says, and I think this is instructive in answering your question. So your question assumes that it might be possible for the stimulator to deliver a damaging level of electrical charge. Something that was
It's not my position. I'm trying to understand what your client's position is.
Or your question.
Yeah.
And that's based on an argument that was made by appellee defendants in the trial court. And there is 0 evidence. Nobody has ever said that.
What is your client's claim then? Given this source of confusion, can you clear it up for me?
I'm going to read Dr. Joel's description. The electrodes had moved away from the midline over to the left side and into what we call the epidural gutter, where they are not only not effective, but they can actually stimulate nerve roots and cause some more discomfort, which is what the patient described to me. So he doesn't say they can deliver a damaging level of electrical current. He says they can deliver enough to be discomforting. So Mrs. Fish had described to him in the history both, I'm not getting the therapeutic pulse, and I occasionally get a discomforting sensation.
Okay, so is the claim then that the reaction to the initial discharge, the physical reaction to that, moved electrodes from the stimulator and caused further discomfort? Or is the claim that the initial discharge somehow damaged the stimulator itself internally?
The claim is that the charge from the treadmill caused several damaging things to Mrs. Fish. One is it caused her head to whip.
Understood.
Which caused injury or exacerbation to her prior neck injury. It also, the electrical current that went through her, caused numbness and pain.
Okay. And is there more?
Excuse me?
Is there another claim on top of that?
In addition, it is claimed that that electrical current from the treadmill damaged the stimulator.
Internally or positionally?
Dr. Joel, in his note, said, offered two possible ways, and he couldn't tell without further examination which one of the two were likely. So he said the violent movement of the head could have dislodged it and or damaged the leads to cause them to not function properly, or the current from the treadmill could have, he didn't use the word overloaded or shorted out, but he said the current through it could have damaged it. So he said, I can't tell which way it was damaged, but I can tell it's not working properly now.
Okay.
And he said further, and this is part of the damages in the case, we need to remove it. So she then had to have a surgery that she wouldn't have had to have if she hadn't had that electrical current go through her, which is another item of damage in the case. Okay.
So I think you've clarified the landscape significantly, and I appreciate that. Where among all of those possible claims do you see, or would you concede that expert testimony is required? Where, if anywhere?
I believe that the defendant is correct, that we need to show that the treadmill has the capacity to discharge into the patient.
The question, so I'm clear, the question that Judge Swan asked you is where an expert is required. So are you saying that you had to have an expert that would show that the treadmill was capable of discharging that type of, and we'll say shock, just so that we're all on the same page, discharge that type of electrical shock?
Yes, Your Honor. So I was trying to answer Judge Swan's question. So I believe the question is, what expert testimony is required on the various things we've just discussed? And number one, we need expert testimony that the treadmill was capable of discharging into the patient. Clearly, Mr. Baer's affidavit does that. Clearly, Judge Gentry said that on the motion for reconsideration, plaintiff has evidence of this. I don't believe it's enough. So that's category one.
And we know, I think a layperson can testify that walking on a carpet and touching a doorknob can do that. Do you need an expert to testify with regard to the grounding strap to establish negligence?
Not to establish negligence. Negligence is shown by the lay testimony of the staff at the gym that they're required to check the functioning of the anti-static line on a monthly basis, and that they had failed to do it for 9 months, and that at the time of the incident, it wasn't there.
Did Mr. Baer give an opinion regarding the type of shock that was capable of being discharged from that machine? I mean, is it a 110 volt, or is it a 220 volt, or is it like I get when I touch a doorknob?
He didn't quantify it, if that's the answer to your question. He said it would be capable of delivering a painful electrical current. So more than the walking across the carpet and shaking somebody's hand, which is, I wouldn't consider painful. I would consider it quite noticeable and surprising. So in further answer, Judge Swan, to your question, what type of expert testimony do we agree is necessary? Number one, treadmill is capable of discharging electricity. Number two, the plaintiff suffered an injury as a result of the electrical discharge from the treadmill. That is supported by the primary care physician, the emergency room physician, and the board-certified anesthesiologist. And then finally, we would need expert testimony that the incident, either through its mechanical nature, the whipping of the head, or through the electrical current, was the source of the malfunction of the device.
And that, okay, so if we agree that expert testimony is required for that, I assume you would concede that no such expert was disclosed within the bounds of the court's scheduling order.
No, Your Honor. So Rule 26...
Did we concede, or no, it wasn't disclosed?
No, I don't concede that. So Rule 26.1 requires an independent expert's opinions to be disclosed, but it doesn't require a treating physician to be identified in the section called expert witness, as long as the treating physician is identified as a witness and the medical records which contain the opinions are disclosed. They were. Subsequently, also, in the early time frame, Judge Rea said we would also be able to use, to oppose the defendant's summary judgment motion, the treadmill witness. We call him an expert. They say no. But the treadmill witness was identified to give opinion testimony about the functioning of the anti-static line, which, as the defendant points out in his motion for summary judgment, is a subject of expert testimony and not of lay witnesses. So Judge Rea said we could use the testimony of their treadmill expert, which when they produced a witness, turned out didn't have that expertise. Judge Gentry ultimately, untimely, but ultimately said, yes, you may substitute your own expert, Mr. Baer, in place of the one identified by the defendant. And that expert, Mr. Baer, did testify about the capacity of the treadmill to discharge to the user. So I'd like to reserve my remaining time for rebuttal.
All right, thank you.
Thank you, Your Honors. Matt Clyfield on behalf of the Appellee Lifetime Fitness. I believe that the court recognized some pretty important considerations as it bears upon what Judge Gentry's decision was here. And I think the very threshold consideration on the motion for summary judgment was simple. Was this treadmill capable of generating a shock sufficient to cause the injury or damage complained of by the plaintiff? And where's the evidence to support that? And that's ultimately what Judge Gentry was looking for. And it was within the context of obviously the deficiencies in the plaintiff's disclosure that the plaintiffs attempted to prove this point.
I'm wondering if expert testimony is really required in the 21st century to have a jury recognize that rubbing your feet on rubber can generate a shock. I don't think there's a person alive who hasn't received such a shock from a similar phenomenon. Why do you need expert testimony for that?
I agree. You don't when it comes to that. The question, though, isn't whether or not you can experience a static shock by rubbing your feet on carpet and touching somebody's hand, but whether or not you can experience a shock on a treadmill of this type, manufactured by this particular company, sufficient to cause the injury complained.
I don't know that It's not a product defect claim. I'm not sure that the treadmill of this type manufactured by this company is all that relevant. As I'm hearing the claim, it's that she received a shock. She received it. You could have received that shock walking on carpet. You could have received it on a treadmill. But the fact is, she received it on your treadmill, and the equipment designed to prevent that from happening wasn't installed at the time. The remaining mechanism of injury, it sounds to me like some of it requires expert testimony and some of it doesn't. If one receives a shock, it's not hard to imagine a reflexive twitch that could injure some people. So all of that strikes me as possibly within the bounds of lay experience.
Well, and I respectfully disagree with you, because I think the very point that you made earlier with appellant's counsel is a shock can be any number of things: walking along the carpet, touching hands.
Well, I think everybody agrees that the shock at issue in this case was an electrostatic discharge, that it wasn't 110 or 220 line voltage with a more or less infinite current supply. It was a spark.
I think there's disagreement there, and the disagreement is clearly, I believe, set forth in our position papers, and that is one of the very threshold questions here is whether or not the shock that was experienced by the appellant was a shock generated by her spinal cord stimulator as opposed to something that damaged it. Keep in mind, the evidence in this case is presented.
That's a disputed fact. I don't doubt that can be a disputed fact, but that's not the same as saying it's something that expert testimony was required to establish.
Well, and I think that the critical question is the severity of the shock. You can touch somebody's hand, experience a shock. Is that shock adequate in its severity to cause you to experience a whiplash type event, to cause you to experience some dysfunction in this electrical spinal cord stimulator or movement of the electrodes? And I think that clearly is where you need expert testimony. Somebody may experience a static electricity shock. It can cause you to feel that that's painful. Oh, that hurts. But is that shock of significant enough severity to cause you to suddenly experience a whiplash either related to, caused by, or causing electrodes to move, causing a spinal cord stimulator to malfunction, to dysfunction? And I think that's properly where appellant just acknowledged that, yeah, an expert is necessary. And I think that's what was before the trial court, the recognition that an expert was necessary on these causation issues, given the damages claimed and the dynamic at issue. Keep in mind, too, there perhaps is, maybe it's disputed, maybe it's not, but as it relates to this particular treadmill, as compared to what Mr. Baer addressed, he didn't address this particular treadmill, he addressed the concept of treadmills. As it relates to this particular treadmill, the only evidence presented wasn't by one of our witnesses, it was by the manufacturer's witness. And he explained that this anti-static guard isn't there really to protect the person, it's there to protect the electronics within the treadmill itself. That's why he wears a anti-static wristband when he's working on them. So it's not there to protect from physical injury, which is, I believe, and would submit a demonstration of the inadequate charge that you would experience from a static discharge on this particular manufacturer's treadmill. It's there to protect the sensitive electronics in that particular treadmill from a static discharge. I don't think that's a dispute.
Hold on, you lost me, because he's wearing a protective gear to make sure he doesn't get shocked.
No, sir. To make certain that the static charge is discharged as he's working on it, that it doesn't build up.
He doesn't shock the equipment.
Exactly. Yes, sir. And keep in mind when we evolve into consideration of what the expert testimony is in this case and what's required in that regard and what Judge Gentry considered, we considered against the backdrop of 702, and we all know that we now deal with that from the perspective of what the Daubert analysis provides and requires. They presented Mr. Baer as an expert who'd never evaluated this treadmill or any treadmills. He was not an expert by way of designing or manufacturing treadmills. He was not a person that performed particular testing on treadmills, did nothing to ascertain the nature and extent of any static shock that could discharge to a user of any treadmill, let alone this treadmill, let alone render opinion that that static charge was so significant as to cause some type of a pain to the plaintiff appellant in this case. And that's against the comparative consideration of we know that we have a malfunctioning spinal cord stimulator before this incident occurred. In fact, the very record that the appellant's counsel read from Dr. Joel's.
Do we know that we have a malfunctioning stimulator, or do we know that we have a displaced one?
Well, Dr. Joel, I submit, testified that it's both. You've got displaced cords. The electrical leads, they're not where they're supposed to be. They had windshield wipered. They were moving back and forth well before this incident occurred. And in fact, I believe the record reflects that the appellant reported to Dr. Joel that she was experiencing discomfort with this. Keep in mind, too, that we have only one alleged incident involving this treadmill. Yet the record clearly demonstrates that after the appellant left the gym, for days thereafter, she experienced electrical shocks, clearly related to a spinal cord stimulator. That was the concern that she had, that it was dysfunctional. Dr. Joel does diagnostic studies that demonstrate, in fact, that the electrodes are displaced just as they had been displaced prior to this incident occurring. They had windshield wipered out of position just as they had prior to this occurrence. They had never moved back. They basically were in the same place, the same condition as they were prior to this incident occurring. And so it really is what comes first, the chicken or the egg here. What caused this jolt, this shock? Was it the spinal cord stimulator, which is an electrical device implanted in this woman's body that was causing problems beforehand, had to be repositioned multiple times beforehand? Or was it a static shock from a treadmill that there's been no evidence presented that it's capable of generating a shock adequate to cause any physical injury, let alone damage to an electrical implant?
Well, again, I think the argument, as I understand it now, is not that the shock itself caused physical injury, but that the shock caused a reaction that exacerbated a pre-existing injury.
Well, I heard that statement today, and I believe, even in the context of making that statement to you today, the representation was that it was only one of several claimed injuries. I would submit, the only suggested injury that was a physical injury directly as a result of responding to a static discharge shock. And I would submit one of the threshold questions.
Were any of the theories that you heard articulated today new to you? Or would you concede that they had all been advanced at some point in the lower court proceeding?
I would suggest that I think it's fairly read into some of the papers that it would have been forwarded below. Yes. I don't suggest it was something I've heard for the very first time today. I've read into it, Your Honor. Yes, sir. But the threshold question is what's causing that jolt? That's what Judge Gentry had to consider. Was it the implant because it was malfunctioning prior to this incident, or was it this discharge, this static discharge from a treadmill, when the device that was replaced is a device that's not designed to prevent injury to individuals on it, but rather to prevent any damage to the sensitive electronics in it. That's where I submit plaintiff appellant necessarily requires expert testimony. In fact, I would submit that the appellant has conceded that throughout this case. That is the position that they've.
Where is our testimony? What is it undisputed that the I'm calling it a ground strip, but you're calling it something else, is intended only to benefit the electronics inside? As
it relates to this particular device, this particular treadmill manufactured by, I believe the company is Life Fitness, the individual that they presented in response to a 30B6 notice that is not our expert, he was disclosed as a lay witness, said, that is my understanding of the intended purpose.
So there's no expert testimony on the intended purpose?
Nothing beyond that. Nothing beyond that testimony.
If a lay witness says, the reason we use three-prong outlets in the United States is so that chassis are bonded to ground and electronics don't get damaged, wouldn't it be possible still for even lay people to say, no, that's also a safety measure for people?
Well, first of all, the statement that the lay witness made, I'm not certain that I know that through my common knowledge. I see a ground plug because that's how I buy it. That's how I'm required to get it. If I got a three-prong plug, I got to plug it in.
And you probably know from lay experience that if you take a pliers and break that off, that it's kind of dangerous.
I think when you modify any product intentionally, it could be dangerous.
And so that's what I'm getting at. We keep saying that the purpose of this device was only to protect the electronics inside, but I don't see that established by undisputed expert testimony?
It's established by the testimony of the employee representative of the company that made it. That's what the purpose was for that particular device.
But the employee representative doesn't necessarily know what he's talking about. He wasn't presented as an expert in this area. The plaintiff's representative could have been the person who chooses the paint colors for the treadmill and still does not really understand ESD.
Well, he was presented, I know, by an attorney who was responding to the 30B6 notice, and to the extent there was a concern that the categories that were enumerated by the appellant in their 30B6 notice were not adequately addressed by the witness, they could have certainly filed a motion to compel another witness to be more responsive. They chose not to do that. The other side of that ledger is that the plaintiff who carries the burden of proof in that respect, that carries the burden of demonstrating that this static guard, this static tinsel, as it's called, not being present at the time, is adequate to, is a device that would have otherwise prevented an adequate electrical charge to cause the injury experienced by his client. He had no expert witness in that respect. He had no expert that done any analysis in that regard. It's clearly conceded, if not by actions or words, that plaintiff appellant required an expert in that subject. That's ultimately why they, in a last-minute haste, retained and disclosed Mr. Baer. Yet Mr. Baer didn't do the work, I submit, as we raised in our reply brief on the motion for summary judgment, our reply to the motion for summary judgment. He didn't do the work necessary to satisfy the requirements of 702 to render opinion that this particular treadmill caused an electrical discharge into the plaintiff adequate to cause her any type of injury, whether it be whiplash, whether it be movement of electrodes, or whether or not it be dysfunction of the stimulator device itself. And in turn, Dr. Joel never said that either. In fact, Dr. Joel's records don't render such an opinion. And you don't have to go any farther than looking at what was done in his deposition to recognize that the leading questions posed by appellant's counsel took him well outside of the scope of what his medical records revealed. So ultimately, Your Honors, with that, I believe that the question properly before this court really isn't whether or not Judge Gentry abused her discretion in limiting witnesses or excluding particular witnesses in terms of the scope of their testimony, but rather whether or not the appellant adequately demonstrated evidence sufficient for her to believe there's a factual question establishing that, number one, this device was capable of discharging electricity in a sufficient current or concentration to cause any harm to the appellant, let alone the damage complained of in terms of the spinal cord stimulator, movement of the electrodes, and the symptoms in her neck or back, given the pre-existing experience she had with that spinal cord stimulator and the pre-existing physical symptoms and disabilities she suffered as a result of that condition. Appellant's counsel presented to you various excerpts of medical records of an emergency room physician and other emergency doctors, and those are individuals who are basically assuming what the plaintiff told them is accurate. She experiences neck and back problems, but is that as a result of a dysfunction in her stimulator caused by this treadmill experiencing a sufficient static discharge to cause it, or is that a result of her spinal cord stimulator dysfunctioning as it had numerous times before? That was the question the plaintiffs did not answer through necessary expert testimony. Any further questions with that? Thank you.
All right, thank you. Counsel.
Thank you.
Let me ask that you hit the last point first. There seem to be a couple of theories for why your client suffered injury and discomfort, and I'm not sure that any of the doctors resolved that question or purported to. It seems like basically you have an expert who says we need to do more investigation, and that investigation was never done.
All three physicians who examined her said she had an injury from the electrical current. So the first, the
They don't
PC...
say which electrical current. What we know is that there are displaced electrodes both before and after, and what we don't know is where the electrical current that caused her injury came from, unless I'm missing something in the record.
The ER doctor made no reference to, so first of all, the only person who's ever said it could have come from the stimulator is defense counsel. There is no witness who said that. That's defense counsel, and he is no expert. So the ER doctor said altered mental status as a result of shock. That was the PCP. The ER doctor said electrical injury, and Dr. Joel said non-fatal effects of electrocution.
Okay. But again, we have nothing to suggest. I think we clarified this at the outset. We have nothing to suggest that this was anything other than a static discharge from the treadmill, right? There's no line current. There's no connection of your client to the power grid.
And to clarify something you, as part of your conversation with appellee counsel, the three-prong plug grounds the line current,
right,
and we have no reason to believe that it malfunctioned. That is a separate safety device from the anti-static line.
I understand that, but because our time is limited, let me then ask you, if all we're talking about is an electrostatic discharge from the treadmill, and all of your medical experts say that there are effects of shocks and electrocution, do any of them suggest for a moment the source or rule out the stimulator with the displaced electrodes as a source?
Dr. Joel, very specifically in his October 5th, 2012 note, said that the alternate causes of the non-functioning / malfunctioning stimulator there were two choices. Mm-hmm. It could have been caused by violent movement of the body of Mrs. Fish, or it could have been caused by the electrical current that she reported going through her from her right foot to her left hand. Either of those are the result of the electrostatic discharge.
No witness says more probably than not it was caused by the treadmill.
Well, Dr. Joel said it was caused by the discharge of electricity in the September 22nd, 2012 incident. And what he said was one or both mechanisms could have caused the malfunction, and he wasn't able at that moment to say on October 5th, 2012, which one it was. He said a discharge of static electricity is sufficient to damage the microfibers in the stimulator leads. He said the mechanical effects of the plaintiff's whipping her head.
Thank you.
All right. Thank you, counsel. The matter is deemed submitted. Decision will issue in due course.